This is the story of a neighbourhood dispute that got way out of hand. McLelland and Symons both ran dairy farms in Western Victoria, and they had a common boundary fence. The fence had fallen into disrepair, and they had been arguing about how and when to repair it. The sticking point seems to have been whether there should be 3 or 4 fence posts for every 20-metre section of fence. Conversation got a bit heated, but the two of them agreed to meet at the fence line to make some final decisions. McLelland took with him some farming tools and an old .22 caliber rifle. He later claimed that he had taken the rifle in order to shoot rabbits. When they met up, the discussion quickly became heated. Symons put up his fists and said, "You old coot," which apparently enraged McLelland. McLelland grabbed the rifle, pointed it at Symons while trying to load a bullet into the chamber. He seemed to fumble while putting the round into the rifle, and Symons reacted by striking out with a metal bar. Evidence differs as to whether he struck at the rifle or at McLelland, and whether he struck once or twice, but afterwards McLelland was on the ground with a serious head wound and the rifle was broken. Symons called the ambulance. McLelland, the guy with the gun, sued Symons for assault. Symons argued that it had been self-defence. Now, you can't plead self-defence if you actually induced the person to attack you in the first place. And McLelland's lawyers argued that by putting up his fists, Symons had started the fight, and McLelland was merely defending himself when he loaded the rifle. Justice Scholl in the Supreme Court said, "I cannot think it is the law that a threat of assault with fists, even though made by a bigger and heavier man as the defendant was, justifies the party threatened in pointing a loaded rifle in such a way as to suggest that he is about to discharge it, or even that he is prepared to discharge it. I do not think it can be said to have been reasonable self-protection on the part of the plaintiff to act as he did." This case shows us that in the tort of assault, self-defence is a defence, but the defence must be proportionate to the threat.